I think, well, over the years, of course, maybe 20, 25 years ago, family life was a lot simpler. So quite often you could have pretty much a standard will, almost a one size fits all. And of course, that's not the case now. We live in a world where blended families are everywhere. People are worried about sideways disinheritance. They're worried that there might be a divorce in the family. So the important thing is that we have to keep on top of all the legislation that there is. We've got to understand the nil rate ban, the residential nil rate ban, which came in 2017. People have lots of different ideas about that. It's important that we understand exactly how that works to ensure that families get the maximum tax allowances that are available. And if you live in a blended family, this is where things like a property trust are very, very useful to ensure that you can protect your spouse, but also importantly, later on you'll be able to make sure that your own children inherit your share of your estate, but you're leaving protection for your spouse at the same time. So all these things that we need to keep on top of and we need to understand so that we can explain them to our clients and offer them the very best service we can. Yeah, so typically we'll find these days you sit down with a husband and wife and they have children from previous relationships. This is a second marriage for them, and both of them have children from their first marriages. They want to protect each other, of course. Blended families, sometimes they get on, sometimes sadly they don't get on, and that's where it's important to understand the family dynamic. To have a really good listen to what people want to achieve and try and pick up where the problems are likely to be so that we can then offer the best solution. But it's very common these days, probably half the people I see have got children from a different relationship, and of course they want to protect those most importantly. So that's where we come in and can give them the best advice available. What can happen is, of course, that your child or your children are going to miss out on your inheritance, because the fatal error that can be made is to trust one another. Well, we'll leave everything to each other, and then when the second one passes away, they'll make sure that the estate is shared among all the children and stepchildren. And of course that may well work out, but there's no protection in there, and you can achieve exactly that but by using particular trusts that we specialize in and we can advise on. And then you can guarantee that you can look after everybody while you're alive, but you can ensure that what you want to go to your children is going to go to them should you pass away before your spouse, that your children are not going to be written out of any future will, which of course is something that can happen. It's important, I think, to review your will maybe every 4 or 5 years. Quite a lot of the work that I do is with clients that I've met previously. And their situation has changed. Maybe a child has come along, maybe sadly a child has passed away or someone's passed away. So it's important just every 4 or 5 years to sit down and make sure that the will you've got in place is the right one for you and it's doing what you want it to do. I think ideally our core clients are people in their 50s and 60s. In terms of thinking about estate planning, there's no time that's too soon. I think it depends on your situation. Young people can inherit money. I had one client who inherited, a good £500,000 at, in a very early 20s. Important to start thinking about estate planning at that point, even though she was not married and had no children. It's still a large sum of money that needs to be protected. So there's no real age at which to start. But the most important thing is to talk to people like us and make sure that we can help you put the right documents in place. Okay, well, I'm always happy to talk to anybody on the phone. I quite often get asked to ring a client. They have a question about something. I'm always happy to talk to them. There's no charge for doing that. The only costs come in if people get round to making documents with us. Then obviously that's where we do make a charge. But I very much take the view that just helping people, first of all, answer any questions they've got, try and build up a bit of trust with them. Hopefully they can get to hear you, see you, if they feel that they can trust you, that's the starting process, to be able to sit down and then have a good conversation and help them get their estate sorted out in the best possible way. Well, in this day and age, I think particularly since the pandemic, most people are used to using video, Zoom. So I quite often will have a conversation over Zoom with clients if they are busy. Perhaps if they live a little distance away, I'm more than happy to have a conversation on Zoom. I prefer to meet people face to face if possible, but video calls are certainly an excellent way of getting the process started. Right, okay, so once we've had a meeting and we know exactly what it is that the client wants, we produce the documents. Wherever possible, very important, I feel very strongly about this, that one should be present to make sure that the wills are signed and dated correctly. So that's very important, something I always endeavour to do. We had a period during COVID when this could be done over video calls, but wherever possible I like to be there in person. I'm generally one of the witnesses to the wills, and then you can walk away and know that if people aren't taking up the storage option, at least you know that their wills were signed and they're legally valid, and they should be kept safe.